Good evening and welcome. Let me just thank you for joining us tonight. My name is Liana Garcia, and I'm the Director of Gift Planning at the Community Foundation for Greater New Haven. The Community Foundation, in collaboration with partners such as trust and estate attorneys, wealth and financial planning advisors, accountants, and insurance professionals, among others, strives to offer you high-quality education, professional education programs. So we are very excited to offer you tonight's program in the hope of elevating the value of philanthropy as a means of enhancing your client relationships. Before starting our program, I want to go over some housekeeping points. All participants will be muted during the presentation. If you have any technical problems, please feel free to communicate those in the chat area. During the presentation, you can submit your questions for the speaker via the Q&A function on the toolbar located at the bottom of your screen. Now on to our program. With the passage of the Secure Act of 2019, advisors were faced with the elimination of the very popular Stretch IRA. Here tonight to talk about the effective alternatives for your charitably minded clients is Johnne Syverson. John is the Vice President of Gift Annuity Services at the National Gift Annuity Foundation. He is a certified financial planner, an accredited estate planner, and a chartered advisor in philanthropy. For more than 40 years, he's helped individuals integrate philanthropy into their traditional financial and estate planning processes. John holds a Master's of Science degree in Financial Services from American College. During his free time, John is a member of the National Association of Charitable Gift Planners, the American Council of Gift Annuities, the past president of the Mid-Iowa Planned Giving Council, and past president of the International Association of Advisors in Philanthropy. He's also the proud owner of a Harley-Davidson. It is my honor to introduce him here today. Welcome, John.
Well, thanks, Leanna. Hello, everybody. What are you doing at 5 o'clock on a webinar? That's what I want to know. We should be out riding motorcycles, but it's only 35 degrees in Des Moines today where I am, so I got it in the garage. Well, let me see if I can share my screen here and hopefully it'll work. All right, look at that. Technology is working today. So yeah, as Anna indicated, that we're going to talk about kind of the what I call the charitable stretch IRA that came out of the Secure Act of 2019. So our agenda today, we're not going to have an introduction by Brian Klons, who's president of Charitable Solutions LLC, that is connected with the National Gift Annuity Foundation. The reason he's on here is we gave this presentation a month or two ago to 600 nonprofits around the country that were interested in the same topic. But we are going to go through some topics of the Secure Act of 2019 that brought this around, remind you what the old IRA rules were for distribution, talk about testamentary life income gifts in general, and then review lifetime CRTs and charitable gift annuities for those of you that may not be totally familiar with them. And then get into the testamentary charitable remainder trust as an alternative to the stretch IRA, which is being commonly spoken of on national forums at the advisor level and the charity level as well. Then I'm going to also talk about testamentary charitable gift annuities, which you're not hearing much about yet. And then I'm going to compare the T-CRT to the T-CGA, so you can kind of see and contrast the similarities and differences. Talk about some tax rules or lack thereof, and then talk about how to actually implement a testamentary CGA if you have a client that would like to do that. So how's that for an agenda? And I'll give you some next steps. What we have here, just so you're familiar with Charitable Solutions, is Brian Klons. This is a for-profit consulting firm that deals with nonprofits all over the country. The main thing that we do is non-cash asset risk management. We help nonprofits bring in through the Decamai Foundation gifts that would normally be turned away. In fact, Since 2003, we've taken in 1.3 billion of charitable gifts that were actually turned down by charities because they weren't cash or marketable securities or real estate. We can take all types of non-cash assets, collectibles, closely held stock, even Bitcoins. Charitable Solutions also does virtual currency and life insurance appraisals and audits. Life insurance appraisals are important if a donor wants to make a gift of a life insurance policy that's more than $5,000 of cash value in it directly to a charity. So that might be something of value. And then also we have actuaries on staff that'll help manage existing charitable gift annuity pools for larger charities that are doing their own gift annuities. We have a couple of attorneys on staff that help with charitable estate settlement and getting assets where they belong, especially if they're going to charity. Brian Klons does about 80 speeches a year on these topics, primarily to nonprofit groups in the plan giving arena. But today I'm here representing the National Gift Annuity Foundation, which is a subsidiary of the Decomai Foundation out of Florida, that can issue CGAs in 49 states, and we grant out 100% of the residuum to nonprofits. So the National Gift Annuity Foundation is able to host gift annuities for those nonprofits that couldn't or shouldn't be hosting their own, and put them on a level playing field with the very large hospitals and higher education organizations that do. So that's enough of a blatant commercial. As far as myself, I think Lana kind of gave you the background, but I'll just give you a little insight. I started in the financial services world in 1972. It either makes me a survivor or just plain old, I'm not sure which. But it was not until 1984, 12 years later, after I'd been advising people who had some professional designations and all that in the estate planning arena on the insurance side in those days, that I went to a conference in Boston and signed up for a 1-hour presentation, a breakout on charitable estate planning. Well, I've been doing estate planning for 12 years. I thought I knew everything. Heck, I was 36 years old by that time. What do you know when you're 36? And I was charitable myself and thought, well, if I can't give away enough money myself, I can teach other people how to do this. So I went and in 1 hour turned everything around for me, because I was exposed to the Tax Reform Act of 1969, which is now over 50 years old, in which we created pooled income funds, we created charitable aid trusts, charitable remainder trust, and so on. And so since that time, I've incorporated charitable planning into my private wealth management firm. We have a field and wealth management firm that's been in Des Moines for about that many years. I'm in Des Moines, Iowa, center of the country, flyover country for most of you folks. And so that's where I'm coming from today. I'm coming from as much as an advisor perspective as a nonprofit perspective. But in my twilight years, I've decided to ride motorcycles and help nonprofits develop more and implement some plan gifts that they probably couldn't do otherwise. So that's why I'm now affiliated with the National Gift Annuity Foundation. So the Secure Act of 2019, you're all familiar with it by now, excuse me. Little history. It was passed by the House, back in May of last year, and finally got incorporated in the spending bill on December 17th and passed by the Senate on the 19th and signed by the President on December 20th. Let's do a little more year-end planning here, folks. So most of those provisions took effect January 1st of this year. And it was really the most significant retirement plan legislation since the PPA of 2006. It's pretty significant. Three main changes that I found that relate to charitable giving are they remove the age restrictions in IRA contributions. Now us old folks can still contribute to IRAs, most of whom are not, but they could. The change in the RMD starting age at 72, but we can still do QCDs after 70 and a half, just like we always could. And the big deal was eliminating the stretch IRA for non-spousal beneficiaries, replacing it with this 10-year window that heirs would have to take payout on receipt of IRA qualified plan assets at the death of the owner of those accounts. So that's what we're going to talk about today. Just as a reminder, because I do this for nonprofits a lot, you all know this, there's a 10% penalty prior to 59 when you take money out of an IRA, 59 to half to 72, no penalty. And after 72, if you don't take the minimum required distribution, except for this year, there's a 50% penalty. So it's that tax on the payout that we're going to be talking about today, especially for heirs. And of course, IRAs have been used to, grow assets during a penalty period. You grow your assets and you take voluntary distributions, and then you take mandatory distributions after 72. So the public's becoming pretty aware of these rules. A lot of them are or just slightly improved with the Secure Act. And as far as what those RMDs look like, here's the current RMD rate, although it's going to change next year. I believe they're going to lessen it a little bit. And you can see that at 75-year-olds got to take 4.4 of their outstanding balance as of 12/31 of the prior year, or get a 50% penalty. 90-year-old has to take 8.8, etc. So what does an IRA beneficiary have when they inherit an IRA from a family member or someone else? They can do a spousal rollover if they happen to be married to the IRA owner. They can be a non-spouse or a child and receive some funds. A trust could receive funds, and charity can receive these IRA funds, but it's a matter of how they're then taxed or not. On a spousal rollover, of course, the survivor can then just become the owner, and they've got RMDs at age 72, and they could designate their own beneficiaries all over again, including charity if they want. But if you name a child as a beneficiary, they're a non-spouse, and now that child, upon receipt after your passing of your IRA, has to take that out over a 10-year period. They can take it on the last day of the 10-year period if they want, the first day or any time in between, but they just have a 10-year window, which could be problematic for certain heirs in their planning. There are some minor exceptions for disability and for minor children. But what I found after 40 some years in advising people and seeing heirs inherit money, some children are what we call creative spenders. You see that 56 Chevy? I had one of those. I wish I still had it. But classic cars or just anything with four wheels that's fast is in the gleam of the eye of a new inheritor. How about a new boat? Or let's take some more vacations, dear. You know, we just had the gravy train come in. Mom or dad or grandpa just passed away. So keep that in mind as we talk about how we can help them, these creative spenders. But the new distribution rules eliminated the old stretch IRA where you could stretch it out over the life expectancy of the non-spousal beneficiary. And the new law says you can stretch it over 10 years. That's it. 10 years from the date of death of the holder of the IRA. It applies to all kinds of defined contribution plans, IRAs, 401ks, and 403b plans. And it effectively went into effect on January 1. So if you have an heir right now that's now receiving IRA assets from a deceased that died prior to the 1st of January, they're still under the old rules. They can still do the lifetime stretch if they will. And oh, by the way, if you have questions as we go, you can use the Q&A function, and then the Community Foundation there, Carmen is going to field those questions, and she may interrupt me and actually open up your mic, and we can discuss it right then and there if you want to get it dispatched at that point. So feel free to interrupt. We've got 45 more minutes to deal with this. So the distribution rules, we eliminated the stretch IRA. Yeah, we already talked about that. So a surviving spouse who inherits the retirement account of a deceased spouse is still permitted to roll it over and it becomes their own. They can delay RMDs until they're 72, et cetera. It's just like their own IRA, but they're about the only ones that have that privilege. So is there another approach now that we have these new rules? How about designating a charity as the beneficiary of the IRA? We've been recommending that for about 30 years, at least for a portion of the IRA. Better give it to your local charities than to the government. You just simply name part or all of the balance of the IRA as the beneficiary, and it goes tax-free from the owner's at the owner's death to the charity. But the problem with that approach is it does not provide any income for the children or grandchildren, which was the purpose of the stretch IRA. In my opinion, people that use the stretch IRA were not leaving IRA assets to charity anyway. They wanted to go to the next generation. So that approach really doesn't solve that problem for them under the new rules. But there are other charitable options which do provide income for the heirs and can stretch out that tax liability for them. That's why we're here today. So charitable individuals with large retirement plan accounts might be interested in testamentary life income gifts, such as what I learned about in 1984 in Boston, charitable gift annuities or charitable remainder trusts. So let's just talk about those animals for a minute here. So why would they consider a testamentary life income gift in the first place? Under the new rules, non-spousal beneficiaries now have to withdraw that, the 10-year window is there. By the way, I've used testamentary life income even for a surviving spouse if they didn't want to have to do with managing the money and RMDs and so on. You can still use a testamentary CRT or CGA for them. But if your donors that prefer that they're non-spousal beneficiaries, their kids, grandkids, nieces, and nephews, don't receive that the IRA proceeds all in a lump sum, they can consider naming a gift annuity or a term remainder trust as the beneficiary of the retirement plan if they set it up correctly. So here's the type of a donor or client profile that you'd find that might be interested in this concept. IRA owners with large retirement plan accounts, and believe me, there are some out there. We've got donors and clients that have multi-million-dollar IRA accounts, especially if they're professionals. How about IRA owners with younger adult non-spousal beneficiaries who do not want their beneficiaries to withdraw the entire balance even by the end of 10 years? They don't want them to buy the 56 Chevy, the sailboat, or the vacation. They want to effectively control from the grave and stretch that out over their lifetime. Under the old stretch rules, it was the inheritor that was in charge of stretching, and most of them didn't stretch anyway. They took it and spent it. But in this case, the IRA owner can actually designate a charitable device that will make certain that that next generation receives income for their life. They'll never be poor, but no one can swindle them out of the principal balance. How about an IRA owner with a non-spousal beneficiary that's in a high tax bracket? Sometimes the next generation's in a higher tax bracket than mom and dad or grandma and grandpa, and they would appreciate not having a big dump of income come at them when they're in their high earning years. And then how about the IRA owner who's just simply charitable and wants to minimize taxes, period, no matter who's going to pay them? So those are kind of the four categories that may be prospects for this particular type of strategy. So let's just do a quick review of lifetime charitable remainder trust. I'm a visual learner, so I have to draw myself some pictures. So here you have donors, and here you have a separate charitable remainder trust with its own federal ID number, its own trustees. And this is my tax sheltered umbrella. So anything that goes on in that trust is under that umbrella is in a tax sheltered environment. I learned about that in 1984. Glad I did. It's a pretty useful tool. And also on this trust is a spigot. And that spigot will produce income back to the donor usually for their lifetime. So here's what happens. The donor puts cash or more advantageously appreciated assets, stocks, bonds, mutual funds, close sale business interests, real estate into the charitable remainder trust. The asset gets sold underneath the tax sheltered umbrella, turned into cash, and then the trustee produces income back to that donor for their lifetime. It's kind of like a charitable pension plan. At the death of the donors, whatever is left in that trust gets transferred immediately to the charity or charities that they named in the trust. I'm sure many of you have implemented these. Benefits to the donor, they receive a lifetime income. And I can tell you, as I've dealt with older adults over the last few years and become one myself, people like income streams. They love income streams. From a planning perspective, income streams that don't require management are a pretty nice thing. But there are also some tax benefits to a lifetime CRT. The donor receives a partial charitable income tax deduction when they make the contribution into the trust based on their age and the current Section 7520 rates, which are at all-time lows of 0.4%. At the donor's death, 100% of the balance goes to charity outside the donor's taxable estate. So if there are estate tax issues in the few estates that are left that have estate tax issues, this skirts that. So it's a wonderful tool, been used since 1969. So if you're advising donors and clients, discuss the increased flexibility with a CRT, even for a lifetime benefit. They can have more than 2 life income beneficiaries, which you'll see with the CGA, you can only have 2. We can have 1 or more charitable remainder beneficiaries with a CRT. We had a client that named 6 different charities. You can provide them with a sample gift illustration. If you don't have that capability in your shop, either the charity might have it, or you can go to an independent consultant like our firm. We have all the illustrating capacity in the world to do that, which helps the donor client figure out whether they want to do this strategy or not. And we recommend that the donor work with a qualified estate planning attorney, set up the trust. Can I hear an amen? Yes, I'm speaking to the right group on that. Because that's what it's going to take. You can't just set up a charitable remainder trust yourself. You do need legal help to do that in most states. Now let's talk about lifetime charitable gift annuities, kind of the distant stepchild of the CRT. Kind of works the same. We have donors and we have a a deposit account here. It's usually at a charity rather than a separate trust. And we have a tax shelter umbrella and we have a spigot. So we put cash or appreciated assets to the charity, who then pays life income to the donor. 100% of the value at the end transfers to the charity, or if they're issuing their own gift annuities, it stays at the charity. And here are the benefits. The donors receive a fixed lifetime income as opposed to a potentially variable life income with a CRT. That's either an advantage or disadvantage, depending on how you look at it. But income from a CGA is fixed dollar-wise at the inception. Tax benefits, the donor receives a partial charitable income tax deduction, same type of calculation as we did with the CRT. And at their death, whatever is left in that account is outside the donor's taxable estate, cannot be challenged by heirs, like a will can be challenged, and goes to the charity that was chosen by the donor. So these are very popular, especially for donors with smaller amounts, maybe in amounts of $500,000 or less, is where we often see charitable gift annuities used. Once we get past $500,000, we're saying, man, we better take a look at whether a CRT might offer you more flexibility. This is important here. Generally, the way these CGA rates are expressed by the American Council on Gift Annuities, which I'll talk about in a minute, they actuarially determine that their rates will satisfy everybody with about a 50% residual value left at the donor's passing if they die right at their life expectancy. So we're not trying to maintain principal with the gift annuity. With a charitable remainder trust, we're often trying to maintain principal. Sometimes you don't. If you're paying out 7%, only earning 5%, it's going to go down in value anyway. But with a CGA, they just kind of automatically go down, and you'll see why, because of the high payout rates. There are advantages and disadvantages to any instrument, but with a CGA, advantages, there's some initial income tax deduction for those that want that, but they have guaranteed fixed annual payments for life. It's like a charitable defined benefit plan. Partially tax-free income for a specified period of years under the annuity taxation rules, and the client and donor can leave a lasting impact in their community, which is primarily one of the reasons that they would set this up to begin with. There's a disadvantage from a planner's perspective in that CGAs really are not flexible. You can't change the income amount once you start it. You can't even change the frequency. If you start quarterly, it's got to stay quarterly. But the only thing you can do is discontinue the income payments if they don't need the money later, and give the remainder to the nonprofit early, even if they have not passed away. That's about the only thing you can do with the CGA after it's issued. So let's take a look then at the Testamentary CRT, Charitable Remainder Trust alternative, and see if we can figure out how we can use that as a substitute for the old stretch IRA for trying to protect our next generation from taxation and creditors and predators. So you name a charitable remainder trust as a beneficiary of the IRA. And of course, you can name one or more beneficiaries in that charitable remainder trust to receive the income payments. If it's an annuity trust or it's a unit trust, then it'll be variable payments, or you can set it up for up to a term of years not to exceed 20. At the end of the trust period, whatever the balance supports one or more organizations, or a lot of times they go to a donor advised fund, a community foundation like sponsoring this event. I've done a lot of those over the years because it really provides a lot of flexibility. Nothing wrong with doing that. So let's just see, how would this work? On the left-hand side, if the client does not use this technique and wants to help their next generation, there's going to be a 10-year payout if they leave the IRA to the next generation. That means they're going to have higher taxes, no protection of the principal, and that creative spender can kind of have at it if they want. On the other hand, if we set up a testamentary unit trust, let's say with a minimum 5% payout, set up for either 20 years or the life of the income beneficiary of the heir, they're going to receive regular payouts. They're always going to have income. You're going to have tax-free growth inside the trust after it's funded, lower their income taxes, and it protects the children from themselves and others. So it is a viable alternative. So how do you create a testamentary CRT? Well, first of all, you talk to your IRA custodian, and you just simply say, hey, I've got this testamentary CRT. I'm going to name it as the beneficiary of my IRA at death, either the primary or the contingent beneficiary. And upon the death of the IRA owner, the CRT is then funded at that time with the money coming out of the IRA account going directly to the trust. Then CRT pays out a percentage of those trust assets to the named lifetime income beneficiaries. That percentage was set at the inception of the trust when it was drafted during the lifetime of the donor, a minimum of 5%, maximum of 50% payout. The beneficiaries will pay tax on the income they received each year over the lifetime as ordinary income. It retains its taxable status as ordinary income, just as it would have been to the donor had he drawn the money out of the IRA themselves. So it's just like kind of the old stretch IRA rules, to be honest with you. It's pretty cool, except under the old rules, you don't have to increase it by life expectancy. The recipient just continues to receive their income based on that percentage of the December 31 previous year value. So it actually levels out their income instead of causes them to take increasing income. Then upon the death of those beneficiaries, what's left in that testamentary CRT passes to the charity or charities chosen by the original account owner. So they made a planned gift here, but they also kind of took care of their next generation with this particular kind of asset, which was a kind of a tax-laden asset to begin with. So it wasn't the best thing to leave to them outright to begin with. Here's some considerations for setting up a testamentary CRT. You have to have the CRT agreement drafted now so that it can be named as the beneficiary of the IRA. Now that can be a separate trust agreement, or it can be incorporated into the will or revocable trust of the donor. But you got to have the language there so it can be a viable CRT to then be implemented at the time of the death of the donor. So it does require an attorney to draft that, and you have to pay the fees for that now, not at the donor's death. And but that's the way it is. You need to have that set up so you can actually have an instrument that you can name as the beneficiary at the custodian holding the IRA. And of course, you have to name trustees, investment advisors, tax accountants, all the things that go along with any kind of a term remainder trust are there. But those are, there's some costs that are going to come out of the trust at the time that the CRT is eventually funded. There's no cost for maintaining an empty CRT. It's just like any other empty trust until it's funded. It's not really in effect. So there's no management of it. So for those reasons, a testamentary CRT may only be appropriate for IRAs with significant value. And I'm kind of arbitrarily saying maybe $500,000 or more. Well, and that's okay for those folks that have that and want to spend the money to set that up now. There's nothing wrong with that. But the reason I kind of jumped on this testamentary CGA alternative is for that other group of people that might not want to leave quite that much and might not have that much in IRA assets to leave to the next generation. Can we do it on kind of the economy plan using a testamentary charitable gift annuity instead of a testamentary charitable remainder trust? So here's how that works. Well, we name the nonprofit as the beneficiary of the retirement plan because the nonprofit issues the gift annuity. There's no separate trust. There's no insurance company involved. So you have to detail the terms of the gift annuity in a particular instrument, a document that gets signed by the donor during life. And we normally use the American Council on Gift Annuity Rates in effect at death. We build that into the annuity contract. We don't know what those rates will be because we don't know when the donor's death will occur, but there's a formula that ties it to those ACGA rates when the death of the donor occurs. And at that point, we know what the age of the income beneficiaries will be. With a CGA of any kind, you can only name one or two annuitants to receive fixed lifetime income payments, unlike a CRT where you can have multiple people receiving income. With a CGA, you can only have one or two annuitants. Now, if you have 4 grandkids, we set one of these up for a donor the other day that had 3 grandkids. They set up 3 single life testamentary charitable gift annuities. So you just work it that way. So at the end of the annuitant's lifetime, after they receive the income for their lifetime, then the balance comes back to the organization that set this up, the nonprofit, kind of like the CRT did. So to create this, you have to give the donors special language to insert in their IRA beneficiary designations. And of course, now you're dealing with these custodians, some of which are easy to get along with, and some of them aren't. Some of them give you a line about this long to name your beneficiary. I've dealt with a state attorney here locally that has a 6-page IRA beneficiary designation. Him and Natalie Choate get along really, really well. So you have to make sure they'll accept your designation. And that designation, we actually have some samples of what it would look like because it has to refer then to an actual, the ACGA rates, and those are published rates, but you have to have a CGA document. A testamentary CGA document now, just like you'd have to have a testamentary term remainder trust document now to tie to the beneficiary designation on the IRA. So if your charity that your client's dealing with doesn't have a CGA program, they could work with a third party such as our National Gift Annuity Foundation, who will outsource gift annuities for any 501c3 charity in the country. So let's just now compare the Testamentary CGA to the Testamentary CRT. Let me take a breath here for a minute. I'm trying to stay within our time. Carmen, have we had any questions come in?
We're good.
Okay, well, keep
I
going.
have one question. I'm sorry. This is Liana. John, if there happens to be no money left in the IRA at death, even though one of these testamentary CGAs have been set up, so there's this legal contract, what, in fact, are the repercussions of that, and how would that work?
Diana, that's dealt with in the T-CGA contract itself, which addresses that issue, because that is always a possibility. I mean, the donor could have had to use up the IRA assets during their lifetime to pay for healthcare, and so there's no IRA. And of course, the donor could actually change the beneficiary during their lifetime, or change custodians and forget about the beneficiary. So that's all taken care of in the testamentary CGA language that says this CGA will be funded when and if money actually comes from this particular IRA. Does that make sense?
Yes, thank you.
So there's no compulsion to fund something when there's no funding left, is the point. Mm-hmm. Okay, so let's just kind of compare CGAs versus CRTs. Generally, research shows that individuals in the mature and baby boomer generation, I am one, are concerned about retirement income. I am one. Okay. IRA owners with younger adult non-spousal beneficiaries, nephews, nieces, children, grandchildren, may not wish their heirs to withdraw the entire balance even by the end of 10 years. They might have heirs that are in higher tax brackets who are saying, hey, don't throw a bunch of taxable income at me. I want to defer it. Give it to me later. So the appeal of the testamentary CGA is it's considerably less expensive to set up. You know what it costs to set up a CGA? Nothing, zero. It's less time consuming to set up and to administer, and it's actually less costly because all the administrative costs are borne by a whole great big pool. And our pool that the National Gift Annuity currently runs is $36 million with 550 annuitants in it. You can really get economies of scale when you have that size of a program going. So it's kind of the low-cost stepsister to the Testamentary Charitable Remainder Trust. That wouldn't be the only reason to do it, however. Now, the advantage, if it's an advantage, is that if you think about a testamentary CRT, Charitable Remainder Trust, it pays out a fixed percentage on a moving value that changes each year. With a Charitable Remainder Unit Trust, you might have a 5% payout, but it's 5% of the 12/31 prior year balance that you pay out. If the market went down and your trust went down, your income go down for the next year. If it goes up, your income goes up. So your income will vary with a Charitable Remainder Unit Trust if you're the income beneficiary. With a testamentary CGA, it pays out a fixed dollar amount for the life of the annuitant when it goes into effect at the death of the IRA donor. So it takes market risk out of the equation. There is no market risk. And it's just based on the age of the annuitant at that time and the rates that are published by the American Council on Gift Annuities. So there's no decision to be made. Don't have to worry about a trustee saying it's the right thing, the wrong thing. It just is. It just happens. Now, for a younger area, you might say, well, yeah, there's no inflation protection in there. That would be correct. There's no inflation protection in a fixed pension plan either. It doesn't have COLAs on them. Same type of deal. So I'm just trying to compare and contrast here. This is interesting. What I realized with the testamentary CGA, it does not have a minimum payout requirement like a CGA, CRT does. In fact, I was just working with a young wealthy couple that are in their late 40s, and they wanted to set up a 7% CRT now with a piece of real estate. Couldn't do it because it doesn't meet the 10% remainder test. They're too young. With a CGA, you don't have that issue, and I'll show you why. We can do a deferred CGA that gets the age up there so it qualifies and will fly with the IRS. Some tax rules. I wish there were a bunch of tax rules published on this whole concept, but all we're relying on at this point is one little dinky private letter ruling. It goes way back. The IRS responded to requests for rulings concerning the tax treatment of funding a testamentary charitable gift annuity with assets from an IRA account. It was in a slightly different context, but it passed, is all I can tell you. Now, my friend Chris Hoyt, who's at the law school at the University of Missouri at Kansas City, is looking at this and he's saying, yep, I think it's still going to fly, but it is just one private letter ruling. There's no cases on this. There's no legislation. So it's important to know that. So you know how a private letter ruling works. It's for that particular case. You can't necessarily rely on it, but it's a pretty good indicator of what the service is going to think about. But we do know outright donation of IRA assets directly to charity, that's been well established. We've been doing that for years. And so essentially you're making an outright gift of an IRA asset to a charity, but then you're tacking on the income payments to another beneficiary after that. So you're saying, okay, if I have a donor client that wants to do this, how do I get this implemented? Well, you got to put together that annuity agreement, and that's normally done by the issuing charity because they're on the hook to make those payments. And what we're finding is nationally, there aren't many charities, I haven't found any that's actually created a testamentary gift annuity agreement yet. We spent several $1,000s in the last year since December in legal fees to create a testamentary gift annuity contract. We took our regular gift annuity contract and then had to modify it for all these what ifs because of the fact that it's funded later at the death of the donor. So you got to put in the contract who the annuitants are going to be. You have to name them with their date of birth, their address, their social. You know, it's a contract. And the age at which you have to put a formula in, the age at which the annuity will be based. In our case, our minimum age for issue is 55. So our contract says if the recipient at the death of the donor is only 30, they have to defer payments on their gift annuity until they're 55. It's just in there by formula, but that'll fly. And then you have to have the frequency of the annuity payments quarterly, annually, semi-annually, just like you do in any charitable gift annuity contract. So it's very similar to a lifetime gift annuity contract, except you got these little nuances in there that have to be dealt with. And then you just name the charity or charities, in our case, that the remaining assets should go to following the annuitant's death. And so therefore, the donor, the original IRA owner, is designating which charities they care about. The actual income beneficiaries, the annuitants themselves, don't have any choice about that. They might not have liked grandpa's charity. Too bad. At the grandchild's death, grandpa's charity is going to get the money. So here's just a quick example. We got Sarah Smith. She's a retired professional, age 75. She's got $100,000 in an IRA. She has a 35-year-old granddaughter, Rachel, that she wants to receive income to Rachel at when Sarah Smith passes away. Okay, she doesn't want to dump the money on her. And she also wants to leave a gift to her favorite nonprofit. She wants to do a planned gift, but she can't really afford to give up the funds now, and the money's in her IRA. So let's see. So we got Sarah as the owner of the IRA, age 75. Grandchild's Rachel, she's 35. Keep those in mind. So Sarah got this $100,000 IRA, and she finds a charity that's willing to issue a testamentary charitable gift annuity on the right kind of paper. And then she agrees to designate that charity in that account as the beneficiary on her IRA with her IRA custodian. So she has to connect the two. So far, so good. The T-CGA contract stipulates that it is contingent on the IRA beneficiary designation remaining in place, because that could be changed by Sarah anytime, and on the transfer of the IRA account to the charity. It actually has to transfer. To Leanna's question earlier, what if the IRA is empty? Well, then there's nothing to transfer. So all this contingency language is in this T-CGA contract to accommodate those potential eventualities. So, okay, so Sarah dies 20 years later. She's 95, okay? Her IRA account passes from the custodian, the Fidelity, the Vanguard, the Schwab, wherever it's held, to the charity to then fund that gift annuity. And by that time, her granddaughter, 20 years later, now she's 55. Well, she happens to be old enough to actually qualify for a rate, but and she'll start receiving income for the rest of her life at age 55, even if she's still working, but it's going to be a fixed income stream based on the rates in effect at that time. And then when Rachel finally passes away, then whatever is left in that annuity contract finally passes to the charity. So it's just like the testamentary CRT, it kind of delays it a generation, but at least the charity ends up with something as opposed to nothing if Sarah just left it outright to her granddaughter or left it and didn't want to leave it outright to charity. So you see the similarity between how a T-CGA works compared to a T-CRT. So with a CGA, you can have what's called a deferred charitable gift annuity. And many charities won't issue a CGA to a person under 65 or 60. We'll issue them as low as age 55, but that's it. So you can use what's called the deferral option, and you just put that language right into your contract so that you can make it happen. And regardless of the age, the income beneficiary could be 21 at the death of the donor, and you just defer their payments until they finally reach age 55 down the line, okay? So we can put that right in the agreement. So in this example, if Sarah had died when Rachel was only 45, 55, it would have resulted in an IRA account passing to the charity with a 10-year deferred T-CGA being created. The way to held the money for 10 years and started paying it out as Rachel turned age 55. And that's something I can't do with a testamentary remainder trust. There is no such thing as a testamentary deferred remainder trust. There happens to be with a testamentary CGA contract, just the way they're built. So through our National Gift Annuity Foundation, which is an independent 501c3, currently have about 36 million in CGA assets on about 550 lives. In this case, the donor transfers assets at death from their IRA to National Gift Annuity Foundation. The National Gift Annuity Foundation makes income payments to the heirs for their lifetime. And then at their later death, the remainder goes to the charity recommended by the original donor. The original IRA holder gets to recommend which charity or charities, it can be split, receives the remainder interest in that after the next generation passes away. It's very similar to a lifetime CGA, except there's that extra generation of income payments in there. Who's the National Gift Annuity Foundation? Well, it's actually a subsidiary of the Decomai Foundation, founded by Brian Klons in 2003, which was established. It's a large private donor advice fund that's set up mainly for non-cash charitable donations of real estate, C and S Corp shares, limited partnerships, LLCs, school buses, airplanes, villas in France, whatever your donor wants to put in that's not cash, we can usually take that, turn it into cash, and then fund a gift annuity through National Gift Annuity Foundation. And so we can, fund annuities based on liquid assets or illiquid, which is kind of unusual. There are large charities around the country that use us just for those illiquid asset funding of gift annuities. They might issue their own gift annuities for cash and marketable securities, but we're able to take illiquid assets and actually fund CGAs on their behalf for them if they wish. So we have over 400 million of unrestricted assets in our consolidated entities between NGF and Decomai, backing up the payments to the annuitant. That's really important because there's no insurance company involved here. There's no FDIC insurance. With any gift annuity, those payments are secured by one thing, and that's the unrestricted assets of the charity issuing the gift annuity. So in our case, regardless of which charity receives the funds in the end, it's the assets held at National Gift Annuity Foundation and the Decomai Foundation, its parent, which are backing up those payments. So in conclusion, the testamentary CGA is just kind of a simple solution to overcome what was effectively stopped, that stretch IRA option that the Secure Act stopped for us. The donor can protect an IRA account from the creditors and predators and taxes in the hands of their heirs, if that's important to them, by using this testamentary CGA approach. A charitably inclined IRA owner would like to secure some income for a younger family member should just consider a testamentary CGA. It's just a simple beneficiary change in the IRA account is all that's required to transfer the funds at the owner's death. Just have to get it set up ahead of time. And the charity and the donor also execute an annuity agreement, and at the inception of this, that the IRA custodian will accept, so that they'll name that contingent beneficiary on the IRA as the testamentary CGA contract. Sometimes they actually want to see the contract. And it can be simple and elegant solution for an IRA account for both the IRA holders and for charities alike. It doesn't have to be real complicated. It's a little complicated at our end to get it set up, but once we got it organized now, it's out there and can be a very viable solution where it fits. It doesn't fit everybody, that's for certain. So next steps, let me take a break here. Carmen, were there any questions that have come in at this point?
I'm good.
Okay. If you are a client donor wants to contact us and talk about a testamentary CGA, you can reach us through the National Gift Annuity Foundation. Or you can call me direct. I am in the Des Moines office, and there's my number. You can reach me at, my name is JOHNNE at nationalgiftannuity.org is my email address, or you can just go to our website. And by the way, our website, nationalgiftannuity.org, has this very same presentation that was recorded for the 600 charities a couple months ago, is right on our website under the resources tab. And along with that is posted there a 6-page white paper written by one of our legal staff that from which this presentation was created. So if you'd like those kind of resources, what we can't do, we can't send out the slides, but you can actually download and see the recording if you wish. And actually, I believe Carmen there at the Community Foundation is recording this event as well, and they'll make that available to you. But the white paper could be of value to you because it cites all the resources and where we got this and where we got that and so on. So now at this point, I'm kind of downloaded my brain late in the day. Any particular questions? Let me just pause and see if there are any questions.
Yes, I just got a question. If we would send out your contact information, we're happy to do that.
I'm happy if you would do that. Yes. We work not only with nonprofits, we work with professional advisors and charitable consultants who like to have us come in and help on these special cases. That would be great. Any other questions? Because if not, I have a question for the audience.
And so another question is, are you advising use of pooled income funds?
Oh, well, that's another topic. Well, that's another presentation. I'd love to do that presentation. Yes, we actually have access to a private labeled outsourced pool income fund that you could do a similar thing with. Yes, you could. More often we're using pooled income funds for lifetime gifts. We don't really have a testamentary pooled income fund that we don't have, but we're doing some. In fact, I myself have a pooled income fund. I sold some of the stock of my wealth management company to my my employees, and I put some of that stock into a pooled income fund. They bought it out, and I saved a pile of taxes, and I have a nice little income coming in for the rest of my life, and I've got a nice residual value at my passing. That'll be my legacy to the community. So I love pooled income funds that are less than 3 years old because the deduction capabilities are tremendous. They're like 2 to 3 times what you get for deducting charitable gift to a CRT or a CGA during life. That might be another whole topic that you'd like to present sometime, Leanna. Yeah. That's pretty fascinating from an advisor perspective. It's a wonderful tool that most advisors aren't even aware it's in the toolbox. I wasn't aware until 1984. So there you go.
Thank you for sharing that. Another question is, how does the National Gift Annuity Foundation make money? Better yet, what are their fees?
Happy to share those fees. The National Gift Annuity Foundation actually built our gift annuity program with the help of the American Council on Gift Annuities. And they said, as long as you earn about 4% on the money and don't charge more than 2% for fees, it'll all work out well. Well, we're actually earning about 7% on the money, and we're charging 2%. We charge 1% for administration and state compliance, and 1% for internal money management. And we do not outsource the money management. We manage it all internally because we're RIAs ourselves. So that's how we keep the doors open on this particular aspect of the operation. There's a 2% fee, which in this case with a testamentary CGA isn't charged until the donor's death. It might be 20 years before we get any income, but we don't do anything between now and then anyway. It's just a piece of paper that lies dormant until the donor dies and the CGA is funded. Good question. Legitimate question. Happy to answer that. We all have to get paid. Got to keep the doors open.
And the next question is, does the Community Foundation for Greater New Haven have testamentary charitable gift annuity contracts, and would we refer? The Community Foundation does have a charitable gift annuity program and is certainly happy to work with any clients that are interested in establishing the gift annuities for any, especially for the local charities. We currently do not have an existing Testamentary Charitable Gift Annuity contract, but certainly could work with our legal team and with the National Charitable Gift Annuity Foundation to make that happen. And we too have $670 million of money invested to support the risk that John talked about with the establishment of these annuity funds.
Mm-hmm. That would work.
Let me see. All right, I think, any other questions?
So here's my question for the group. What's the best thing you heard today? If you're still awake.
Let's see if anything comes in. Oh, I don't know. I'm not, we still have people in the audience. I can see them.
They're formulating their answer.
You can type it into the chat, or I can unmute you if you'd like to speak.
We did get a comment that says, John made it all sound so easy.
It is easy if you hook up with the right people that know what they're doing.
Awesome.
Make it easy.
Let me see. There might be. I think that's good. Let's see. I don't see any other questions. So,
Yes, one came in.
Yep. We have someone whose comment is, there are just so many family situations when this charitable solution makes sense.
Yes, yes. Good comment. Yeah.
Thank you.
We had to kind of think it through, but largely based on our own experiences, if you identify the right family situation, you know when to bring it up. It is not for everybody, which are most of these charitable tools are not for everybody. But where they fit, they really fit well, and they just need to be part of the planner's toolbox, in my opinion, including the pooled income fund. I would say the pooled income fund is the least utilized and the most effective tool in the planner's toolbox. I'll make that statement here. I'll give you a preview of my next pooled income fund program.
Well, thank you so much, John, for sharing all of these creative strategies with us today.
You're welcome. It's a pleasure.
Our pleasure to having you. I want to thank all of you for attending this webinar. There is an upcoming presidential election, which will have many of us facing possibly additional changes to our tax code. So please stay tuned to future educational offerings by the foundation. Thank you and good night.
Happy trails.